Well, welcome everyone to today's lecture by Jessica Marglin. She'll be speaking on the subject of nationality on trial, Jews, belonging, and legal identity in the 19th century Mediterranean. This is the first of 6 lectures of the University of Minnesota's Center for Jewish Studies annual lecture series, which is now in its 19th year. The Center for Jewish Studies has brought renowned scholars on a very wide range of subjects on Jewish studies to both the campus community and to the wider public. I'm Daniel Schrader, the director of the Center for Jewish Studies. So I want to invite you to visit the Center for Jewish Studies website to learn more about our lecture series program for this year and other events that the center has to offer. Our lecture series would not be possible without the continuous support of the community and a generous gift in memory of Julia Kay and Harold Segal. Special thanks to our co-sponsors at the University of Minnesota, the Department of History, the Program in Religious Studies and Islamic Studies. And especially I want to thank the support and efforts in these very challenging times of our Associate Director of the Center for Jewish Studies, Natan Paradise, and our outreach and program coordinator, Mario Coulter. And thank you, of course, for all of you present today for this webinar. So it's now my great honor to introduce Jessica Marglin, Associate Professor of Religion, Law, and History, and the holder of the Ruth Ziegler Early Career Chair in Jewish Studies at the University of Southern California. She received her BA and MA from Harvard and PhD from Princeton, and is the recipient of many awards and fellowships, including an NEH fellowship at the American Academy in Rome, and a research fellowship at the Institut d'études avancées in Paris. Her research on the history of Jews and Muslims in modern North Africa and the Mediterranean has taken her for extended stays in Morocco, Tunisia, France, Italy, and Israel, and probably some other countries as well. Her research on the subject has led to some very, very interesting publications, including an award-winning book, actually a book that won a number of awards, Across Legal Lines, Jews and Muslims in Modern Morocco, published by Yale University Press, and this year translated to Arabic and published in Morocco. She's published widely with articles and books and leading journals on a range of subjects pertaining to Jews and North Africa and the Mediterranean and their legal history. Her work is groundbreaking and challenging and challenges us to rethink many of our commonly held assumptions about Jews, citizenship, and belonging in the modern world. So today we're fortunate to hear about Jessica's forthcoming book based on the fascinating figure of a Tunisian Jew, Nissim Shamama, in the 19th century, a notorious figure for those of us like myself who research the modern history of North Africa. But the story that Jessica's uncovered in her research is a much more complicated and revealing tale than certainly I ever imagined. And it really pushes research on the legal history of Jews in the Mediterranean and in the modern world generally in important new directions. But I will leave this to Jessica to tell this fascinating story and its significance. Just before I hand this over to Jessica, just want to remind everyone that during and following the lecture, please submit questions and Q&A in the Q&A at the bottom of your screen in writing, and we will leave time for discussion at the conclusion of Jessica's talk. So I now will hand this over to Jessica.
Okay, Daniel, thank you so much for that incredibly generous introduction. I should have told you not to be so nice so that we could sort of under promise and then hopefully I would over deliver. But anyway, I'll do my best. And really thank you so much to Mariel and Nathan for making the logistics of this all very smooth. And I'm very eager to engage with everybody who's out there listening. These webinars are so odd in some ways because of course I sort of feel like I'm just speaking into the air, but to be able to see all of your names is really exciting and great. And I look forward to the question and answer. And I will try not to go on and on, precisely to leave plenty of time for questions. I'm going to go ahead and start a slideshow so that you can see a few images, which will hopefully make the whole thing a little bit easier to follow. And I'll start with a bit of a story. So the tale begins on January 24th, 1873, which was a Friday morning, Erev Shabbat, when one of the richest men in Italy, actually probably one of the richest men in all of Europe, died suddenly in his lovely palazzo in Livorno, Italy, which is on the Tuscan coast. This man was named Nissim Shamama. He was a Jew, originally from Tunisia, and he was immensely wealthy. So after his death, the search for a will started immediately because, of course, everybody wanted to know what was going to become to all of this money. Now, this was a particularly urgent question because Shamama, although he had been married 3 times, never managed to have children of his own. So it really wasn't clear who was going to inherit his wealth. Even though Shamama never had his own children, he did have a woman who was like an adopted daughter, and that is Aziza Mama. And here are pictures of her, first with her family, and then alone later in life. Aziza was Nissim's niece, rather great niece. She was the daughter of Nissim's nephew, a man named Qaid Momo, whom we'll hear about a little bit more shortly. But Aziza, from a very young age, was estranged from her biological father and went to live with her uncle Nissim, who really came to think of her as a daughter. And she followed Nissim after he left Tunisia, when he first went to Paris and then eventually to Italy. When Aziza had a son of her own, whom you can see in this picture, she named him not after his biological grandfather, but after Nissim Shamama, her uncle and her sort of adopted father. And so he was known as Nissim, or I'll call him Nissim Jr., just to disaggregate from Nissim Shamama, the protagonist. So shortly after Nissim died, the family members who were there at his palazzo and the Livornese police and some lawyers who had been called in managed to find a will. And the will, when it was finally read, divided this estate among Aziza and her young son, Nissim Jr., who got half of Nissim Shamama's fortune. And then the rest went to these 2 people, Joseph Shamama, who was one of Nissim's surviving nephews, and Nathan Shamama. They each got a quarter. And that was how the will apportioned the estate, more or less. There were some smaller gifts for charitable purposes and smaller gifts to other relatives, et cetera, et cetera. Okay, so this could be the end of my story, right? Here's the will, here's how it was all apportioned. But as anybody who's ever studied inheritance knows, fighting over an estate is probably about as certain as death itself. And of course, this is particularly true when the estate concerned involves enormous amounts of money. So very soon after the will was found and read and understood, there were others who started to challenge the validity of the will because precisely they stood to inherit an enormous amount if the will was deemed invalid. Oh, sorry, here is the apportionment of the estate, right? 1/4 to Aziza, 1/4 to Nisim Jr., and then 1/4 to Joseph and Nathan. By this point, I should mention Judah Shamama had died, Nathan Shamama had died, Judah Sr. Shamama had died. Obviously, Nisim's father had long died. So the only surviving nephews were these three, including Khalid Momo, Aziza's estranged father. I'll talk about him more in a second, I promise. Okay. Now, the distribution of Nisim's estate was going to be decided in Italian courts because that's where Nisim Shamama died. That's where he was domiciled. And the principle that was going to decide how to apportion his estate rested on this man, Pasquale Stanislao Mancini, who was an incredibly famous, prominent, sort of larger than life jurist in Italy in the late 19th century, who came up with something known as the Nationality Principle. The Nationality Principle was essentially an idea that said that private law, that is marriage, divorce, and important for our purposes, inheritance, all of these things should follow the national law of the person concerned, meaning that the national law of the deceased person would determine which law governed their estate, right? So in this case, Shamama's nationality would determine how his estate was going to be distributed and thus whether his will was valid. Now, this seems like it should be a fairly simple question, right? What state was Nisim Shamama a national of? To which state did he belong? Now, everybody thought when Nisim died in 1873, everybody thought that he was Italian because he had applied for Italian nationality in 1866. However, as I'll explain in a little bit, it wasn't completely clear if he had actually gotten Italian nationality. If Nisim died an Italian national, then Italian law would apply to his estate, right? Because he would be Italian. And in that case, the will would certainly be upheld. Aziza would inherit 1/4 of the estate. Nisim Jr., her young son, would inherit another 1/4. Everybody, on that side of the family, at least, Aziza and Nisim Jr. would be happy. However, if it turned out that Nisim Shamama had never become Italian, and thus that he had died a Tunisian national, then it would be Tunisian law that would apply to his estate, right? Still Italian courts, but they would be required to apply Tunisian law. And now, stay with me for a moment here, if Tunisian law was the law that had to apply to his estate, then in fact, it would be Jewish law because Jews in Tunisia were regulated by Jewish law for things like marriage, divorce, and inheritance, right? This was one of the sort of characteristics of Jewish life in the modern Middle East, really all over the place, that Jews were still under the jurisdiction of Jewish law for many, certainly family law matters, but also some sort of more public law matters. If that's something you're interested in, I'm happy to talk about that at greater length, as it's something that I've worked on quite a bit. So if Jewish law was going to apply, then it seemed very likely that the will would be thrown out. And instead, biblical law would apply to the estate. And biblical law apportioned the estate between Nisim's 3 closest surviving male relatives, who were Nathan and Joseph, each of whom got 1/4 of the estate in the will, and Khalid Momo, right, the estranged father of Aziza. And if biblical law was applied, right, if Jewish law was applied and the will was thrown out, then each of these surviving nephews would get 1/3 of the estate. Now, this seems like, okay, 1/3 of the estate. For Nathan and Joseph, maybe not such a big deal to go from 1/4 to 1/3, but remember that the size of this estate was truly astounding, right? Nisim Shamama was, as I said, one of the richest men in Europe. Really only extremely rich bankers like the Rothschilds were richer than somebody like Nisim Shamama. So there was a huge amount of money at stake. So even the difference between 1/4 and 1/3 that was quite a lot of money. And for somebody like Khalid Momo, who was almost completely cut out of the will. In the will, Khalid Momo did not receive a large portion of the estate. Nisim Shamama gave him essentially 25,000 francs as a kind of gift. But if biblical law were applied, he stood to inherit 1/3 of the estate. And eventually it was determined that the estate was worth something like 27 million francs. So you could imagine that Momo was very determined to have the will thrown out so that instead of getting just 25,000 francs, he would get 9 million francs, right? Now, all of this meant that in order to distribute Nissim Shamama's estate, right, the Italian courts first needed to answer what seems, again, like it should have been a simple question. What was Nissim's nationality when he died? And I've already talked about the idea that maybe he was an Italian national, the idea that maybe he was a Tunisian national. In the course of the lawsuit, which took a decade, thousands of pages of legal briefs, millions of francs to resolve, it turned out that there were two more options. One, that he would die stateless, that he had lost his Tunisian nationality, but he had not acquired Italian nationality. And the fourth option was that his Jewishness was his nationality, and Jewish law was his national law. And this is something that I think is very interesting in terms of understanding sort of the intersection between nationality as a legal status and nationality as an ethnocultural status. Of course, today we only have limited time together. So for the purposes of this talk, I'm just going to focus on one of these possibilities to sort of give you a sense of how the case played out and some of the stakes in this battle over Nissim Shamama's nationality. So I'll just focus on the question of whether or not Nissim was a Tunisian national. But before I tell you more about the disputes over Nissim's nationality, I want to say a little bit more about sort of the broader stakes. And I want to introduce this term that I'll be talking about a lot, which I call legal belonging. Legal belonging, it sounds like one of those sort of, possibly annoying terms that academics make up to make things more complicated. But hopefully what I hope to convince you of is that it's actually a useful way to think about ideas of citizenship and nationality in more abstract terms that allow us to tell a story that makes more sense for North Africa and the rest of the Mediterranean. What I mean by legal belonging is essentially this. It's a sort of neutral, abstract way to describe the bond, the legal bond that ties an individual to a state. Right? So it's often called citizenship or nationality or sometimes subjecthood. But there were actually many different ways of belonging to a state, especially in the 19th century, that we don't really tend to think about today and that don't necessarily fall easily within these ideas of citizenship or nationality. So colonial subjects, certainly belonged to states, or in this case, right, to an empire, but they were almost never citizens, with some exceptions, and often they did not possess the nationality of the empire concerned. Yet they were subjects; they were somehow attached to the state, and so I sort of include them on this in this broad category of legal belonging. In the Mediterranean, there were also these somewhat sui generis categories of people who did not formally belong to a state, say France or England, but who nonetheless managed to obtain patents of consular protection, right? So let's say a Tunisian Jew, not Nissim Shamama as it happened, but many other Shamamas, right? And many other Jews in Tunisia, certainly, they would remain Tunisian, right? They would remain technically a subject of the Bey, but if they worked for a foreign consulate, then they could obtain these patents of foreign protection, which essentially gave them a sort of bond of belonging to a state like France or to a state like England. And these were further points along what I call the spectrum of legal belonging, right? And there were different ways of belonging to a state, and one could belong to a state in different degrees. So full citizens, right, would have political rights and civil rights, and they would be full members of the state. But of course, in the 19th century, there were many people who belonged to states, but who weren't full members, like women, for instance, and colonial subjects, as I mentioned, et cetera, et cetera. So on the other end of the spectrum would be people who maybe belonged to the state, but didn't have the full set of rights, didn't have the full set of sort of privileges of that tight bond of citizenship. So part of what I'm trying to encourage us to think about is belonging as something that wasn't an either or category. And in this, I actually follow on the work of Sarah Stein, whom some of you may be familiar with, who has similarly suggested that we need to move away from thinking of citizenship as a binary. And this is particularly important when we think about citizenship in the context of the Mediterranean, because terms like citizen and national often come with a lot of historically specific baggage that are particularly European or Western. And legal belonging, I think, offers us a more neutral term that doesn't require us to think of citizenship as something invented in modern Europe and then exported to the rest of the world, including to the Middle East. That's unfortunately how the narrative of Middle Eastern citizenship is often told, as a sort of modern Western invention that gets imported sometime in the 19th century. And it's part of a bigger narrative, right, which is largely discredited, at least among scholars, but remains pretty powerful, in which modernity in general, right, everything modern was invented by Europeans and then sort of brought to the rest of the world. So what I want to encourage us to think about today, and why I think the Nissim Shamama case is so important, is that legal belonging is something that existed really anytime there was a state, right? And that it can be applied across political, regional, religious contexts, right? I think that there was legal belonging in a state like Tunisia or the Ottoman Empire long before the 19th century. But basically because I see legal belonging as a dimension of sovereignty. So if there was any sovereignty in states like Tunisia or the Ottoman Empire, then there was a degree of legal belonging. There was a way in which people were attached to the sovereign, attached to the state. And what I hope to convince you of by the end of the talk is that this is very much how the Tunisians involved in the Shamama case thought about legal belonging. And I'll bring in the voices of a Tunisian Muslim and a Tunisian Jew, originally an Algerian Jew, but who lived in Tunisia, who were very sort of clear that, you know, legal belonging was something deeply rooted in Islamic law and Islamic tradition, and not something that was wholly a province of Europe or modern Europe. And why does this all matter for Jewish history, right? Why should we care? And specifically for the history of Jews in North Africa and the Middle East. Well, first of all, because I think it allows us to tell a story about citizenship that is connected across the Mediterranean, rather than either a purely European story or a purely North African story. And Jews are a good way into this kind of trans-regional story for two reasons. One, because they kind of never quite fit in, right? They never quite fit in either the Islamic context or in the European context, and particularly in this age of nationalism, when new nationalist ideas about belonging are gaining currency, especially in Europe, but also on the other side of the Mediterranean. And also because Jews are always emblematic of the legal hierarchies that end up sort of excluding some members of the state from full rights, right? That end up sort of differentiating the ways in which one might belong to a state. So, you know, to remind everybody, of course, in the late 19th century, in the 1870s and 80s, when the Nissim Shamama case was raging, Jews in most parts of the world were not counted as full and equal members of a polity, right? Either in Europe or in the Middle East and North Africa. There were just a few Western European states like France and Italy that had fully emancipated Jews and gave them, 100% of the rights afforded to Christians. But what's interesting, this is an old story, right? Of course, this is not something new, but what's interesting about the Shamama case and what I think is worth recovering is that it brings up the ways in which, despite not having equal rights, Jews still belonged to the states in which they lived, right? They were still somehow members of the state, even if they weren't full members. And so the boundaries of Jewish belonging, both in a place like Italy and in a place like Tunisia, become opportunities to debate the nature of equality, the nature of toleration, the nature of religious difference, and an opportunity for North African Jews and Muslims to offer this distinctive vision of what equality might mean, one that is often different from the ways we think about equality coming out of a sort of modern Western European tradition. Okay. With that introduction, which hopefully gives you a little bit of an idea of the stakes of all of this and why it should matter for historians and why it should matter just for anybody interested in the history of Jews, and how we can use Jews to understand broader history. Now I'll go ahead and sort of talk a little bit more, go back to the case at hand and introduce you to a few more of the characters. So remember that I mentioned that Khaled Momo was the sort of main antagonist, right? He was the one who stood to inherit a third of the estate if the will was thrown out, okay? But Khaled Momo was not acting alone. He had behind him the weight and the money of the Tunisian government. And that is because, well, for a few reasons. First of all, Nissim Jamama was rather infamous, as Daniel mentioned in his introduction. And he was infamous largely because he was accused of stealing a lot of money from the treasury. So at least after his death, this was the line. It's not actually clear when that narrative emerged. But basically, Tunisian government officials accused him of owing huge amounts of the treasury and wanted to recover some of these debts from his estate. The problem was the Tunisian government didn't have proof of these debts, or at least not proof that would stand up in an Italian court. So instead, the prime minister of Tunisia went to Khaled Momo and essentially forced him to sign a contract in which he agreed to give the Tunisian government 25% of his share of the estate, 25% of his inheritance, whatever that should be. Now, this made the Tunisian government an official party to the estate, and it also sort of allowed them to get back some of the money that they believed Nissim owed him, basically whether or not they could prove that they were a creditor of the estate in an Italian court. So once this was the case, they sent this guy, a man known in Europe as General Hussein. In Arabic, his name was Hussein ibn Abdallah. He was a very high-ranking official in the Tunisian government, and he became basically the head of the Tunisian government's case against the Shamama estate in Livorno. He moved to Livorno and he spent many, many years there. And he was in charge of hiring the lawyers and corresponding with them, and essentially doing everything he could to prove that Nissim Shamama had died a Tunisian national, and thus the Jewish law should apply to the case, and that the will should be thrown out, right? Because of course, this was the way that Momo was going to inherit, and this is the way that the Tunisian government was going to get its share of the estate. Now, Hussein knew that he needed to hire a big shot lawyer in order to prove the government's case. And he found this man, Augusto Piero Antoni, who was a rising star of international law, certainly in Italy, but really across Europe, actually. He was a founding member of the Institut du Droit International, which was really the first sort of scholarly association dedicated to international law, which was founded in the same year that Nissim Shamama died in 1873. And as it happened, he was Mancini's son-in-law, Mancini, who was the father of the Nationality Principle. And by the way, the guy that eventually the other side, Aziza Shamama, hired to prove the opposite, to prove that Nissim Shamama had died an Italian national. So the lawyers themselves had a kind of personal investment in the matter. Now, Hussein and Piero Antoni worked very closely together. And this was partly because Piero Antoni found himself a little bit out of his depth in trying to make arguments about Tunisian law, Tunisian nationality law, Islamic law, Jewish law, et cetera. So he relied a lot on Hussein and on Hussein's sort of networks to fill in the blanks in his knowledge. And when Hussein and Piero Antoni started working on the case, which was already a few years into the matter, because this is one of these incredibly complicated cases. As I mentioned, it lasted a decade. It first went to a sort of, tribunal of first instance, which was the local civil court in Livorno, which ruled in 1877 that Nissim Shamama had died stateless, that he had never been, that he was neither Tunisian nor Italian. And that, therefore, at least according to this court, Italian law should apply, because that was the case for stateless people. Now, one of the things that was difficult for Piero Antoni and Hussein in trying to make the case that Nissim Shamama had died a Tunisian national is that the Livornese court argued not only that Nissim Shamama was not Tunisian when he died, but actually that he had never been Tunisian, that he had never been a Tunisian national. And the ruling explained that as a Jew, Shamama was barred from enjoying full civil rights in a society that was, quote, regulated by the Quran. Those are the words of the court, and which did not guarantee, quote, the absolute equality of all its subjects before the law, regardless of their religious faith, end quote. Basically, the Livornese court was making a distinction between a subject on the one hand and a national or a citizen on the other, right? Subjects might owe allegiance to a sovereign, but they did not have full rights, right? They did not have the rights that a national or citizen would. And because Tunisia did not have religious equality, because Tunisia had not emancipated its Jews, then a Jewish subject like Shamama, in the eyes of the Livornese court, was merely a Tunisian subject, not a Tunisian national, right? So this gets to these questions of the degrees of belonging that I was talking about, right? And this is part of why I think legal belonging is a useful term, because the precise vocabulary for trying to understand questions of nationality and citizenship in this period was very much a work in progress, right? And people were still trying to figure out exactly what a term like national or nationality or citizen or citizenship or subject or subjecthood meant. Okay, so Piero Antoni and Hussein were faced with this argument that Nissim Jama had never been a Tunisian national, and they had to respond. And Hussein's response, Hussein actually wrote his own, he wrote a number of legal memos related to the case. And the one that he wrote, which directly addressed this question of whether Nissim Jama could even be a Tunisian national, is very interesting and is worth going into. So Hussein begins his response by saying, you know what, you're right. It is a society, quote, regulated by the Quran, right? It is a society that is governed by Islamic law. But he counters that Islamic law does not exclude Jews from nationality, from belonging, or from the polity. And in fact, quote, according to him, in Islamic law, nationality is based on religion for Muslim subjects and on the Pact of Zimba for non-Muslim subjects. Now, let me say just a little bit about the Pact of Zimba. So Jews and Christians living in the Islamic world from the late antique or early Middle Ages were considered dhimmis. If this is not a term that you're familiar with, that's fine. Basically, what you need to know is that there was this idea of a pact of protection, ahd al-dhimma, which essentially gave non-Muslim monotheists like Jews and Christians the status of protected peoples who were allowed to, practice their religion and have a certain degree of autonomy. And in exchange, they were accorded a sort of subservient status to Muslims in the polity. So Hussein's idea that Jews were the nationality of non-Muslims, right, meaning Jews, was based on dhimma, was the idea that nationality law in Tunisia was based in Islamic tradition. Now, obviously, Hussein was doing a little bit of translation here, right, because there isn't this sort of inherent use of a word like citizenship or nationality in sort of pre-modern discussions of dhimma, of the protection that it was accorded to non-Muslim subjects. But his point was that citizenship or belonging to the state was something that really could be found in traditional sources of Islamic law, that it was not something that had been imported from the West, that had been imported from Europe, but was, again, part of the Bey's sovereignty over his subjects. And when it came to his Jewish subjects, the Bey's sovereignty was determined by this Pact of Zimba, by this Pact of Protection. So as dhimmis, Jews owed allegiance to the Muslim sovereign, who in turn was responsible for protecting them. Hussein went a step farther. He was not only interested in arguing that Jews were Tunisian nationals, which he was which he certainly believed, but also that Jews were equal before the law to Muslims. And this is what he says: the Islamic religion accords dhimmis and Muslims the same rights and the same obligations. Now, this statement is, frankly, a little bit of a stretch. And again, as I sort of mentioned, dhimmis might have been conceived as members of a polity, but they were very much, at least traditionally, considered to be subservient. And they had a different set of rights and a different set of duties from Muslims, right? And they paid a different set of taxes. They had all sorts of restrictions on their religious and social worlds. And they were precisely not considered to be the equals of Muslims, right? That was sort of the deal. As a dhimmi, you had certain kinds of protections, but you were subservient. You were sort of below Muslims on the social hierarchy. Now, it would be easy to say that Hussein was being disingenuous, that he was essentially, sort of lying through his teeth, or that he knew that his European audience, that the Italian judges wouldn't be deeply familiar with the laws of Zimba. But I actually don't think that's entirely true. First of all, we have earlier writings of Hussein in which he makes the case that Jews and Christians in the Islamic world are not as oppressed as Europeans tend to think they are, right? That there's this kind of presumption that Muslims are inherently sort of oppressive towards Jews and other non-Muslims, and that that's not true. And second of all, his discourse about Jews and Muslims being equal before the law is something that shows up in other places across North Africa around this time, in which reform-minded Muslim officials argued that although dhimmis might be distinct from Muslims, right, that didn't mean that they weren't also entitled to justice before the law. In other words, there was a distinction being made across North Africa by Muslims in particular between the idea of absolute equality, where everybody, Jews, Muslims, Christians, etc., had exactly the same rights, regardless of their religious status, versus a different kind of equality, which could be called equality before the law, in which Jews and Muslims had distinctive rights, they had a certain amount of legal independence, but they could also expect just and fair treatment from the Muslim authorities to the same degree, right? That Jews were entitled to justice in the same way that Muslims were, even if they had slightly different rights and responsibilities. So in this sense, Hussein was making an argument that Jews were entitled to civil rights and thus were Tunisian nationals, right? Not only was their membership in the state based on Islamic law and Islamic tradition and on their status as dhimmis, a very old and well-established tradition in the Islamic legal world, but also that Islamic law afforded them the right to justice and thus the right to equal treatment. Okay, Hussein was not the only North African, obviously, working on this case, even though it was being argued in Italian courts and these big shot Italian lawyers, Piero Antoni and Mancini, were sort of taking the lead. Behind the scenes, there were a lot of different North Africans who were taking part in the discussion. And one of the most interesting and most important figures is a Jewish man who worked very closely with Hussein for the Tunisian government, also trying to argue that Nationality Principle had died a Tunisian national. His name was Leon el-Milik, or that was the European version of his name. In Hebrew, was Eliyahu ben Avraham al-Maliach. And he also, like Hussein, he wrote various sort of basically memos, legal briefs for the case, arguing, again, in various ways that Jewish law should be applied to Nissim's estate. He wrote them initially in Hebrew, and then he translated them himself into French and Italian. He also obviously knew Judeo-Arabic and Arabic. And he was also very insistent on this idea that Jews were full members of the Tunisian polity. And he put it in some ways even more sort of forcefully than Hussein. He said that Jews and Muslims are equal before the law. Ha-Yehudim shav'im hem lifnei hamishpat im ha-Yishmaelim, that Yishmaelim being the traditional Hebrew word for Muslims or for Arabs. And El-Milik is somebody he was a very pugnacious person. He ended up having very explosive arguments with everybody who worked on the case. And you could easily dismiss somebody like El-Milik as making essentially an opportunistic argument, right? Or maybe as an example of somebody with dhimmi Stockholm syndrome, right? That he had kind of been brainwashed into making this argument for Jews and Muslims equality. But I think that, again, El-Milik's assertion of equality between Jews and Muslims was actually part of a much broader agenda on his part to defend the Tunisian government as the guarantor of Jews' rights. And again, this is something that you see not only in his one particular case, but across North Africa. And there are other instances in which Jews in North Africa during this period deliberately try to say that, no, actually, the the Muslim government under whom we live, these are the people who are best positioned to protect Jews and to ensure justice for Jews. And this is something that I found in Morocco as well as Tunisia. And so again, I think, I think we might have these sort of assumptions about why people were making these arguments. But in fact, I think there's very good reason to imagine that somebody like al-Maliyah, somebody like al-Malik, and somebody like Hussein really did believe what they were saying and were trying to present, as I mentioned earlier, an alternative version of what equality might look like and what the boundaries of belonging were for Jews in North Africa and the Middle East. Now, part of what's very interesting about this case is that there are all of these different voices kind of coming out at the same time. And obviously al-Malik and Hussein and Augusto Piero Antoni, the Italian lawyer who was hired by the Tunisian government, the big shot specialist in international law, they were all working together essentially as a team. But they didn't necessarily all agree. And ultimately it was Piero Antoni who was coming before the court and who was responsible for writing the briefs in Italian that the judges were going to read. And Piero Antoni was, interestingly, in many cases, he did echo Hussein's arguments, and he actually used Hussein's words often verbatim in his own legal briefs. But in this case, when it came to Hussein's arguments for Jews and Muslims having equal rights, or at least being equal before the law in Tunisia, Piero Antoni was not willing to echo his Muslim employer. It might be because Piero Antoni thought that it was just too outlandish of an argument, that no self-respecting Italian judge was ever going to believe that a Muslim state actually would ensure a kind of equality for Jews. There was such a widespread perception of the Islamic world at this time as a place of discrimination against non-Muslims that it's quite likely that Piero Antoni just thought such an argument would never fly. But what's interesting is that Piero Antoni wasn't willing to give up on the argument that Nissim was a Tunisian national, of course, right? That was the point of his case. And so he argued based on something else. He argued the idea that one could belong to a state without having full rights in that state. In other words, one could be a member of a state without being a full citizen. He pointed out that Italy had only granted Jews full political and civil rights fairly recently, technically only in 1865, with the promulgation of the Italian Civil Code. Now, actually, there had been sort of emancipation for the Jews of Piedmont earlier, quite early, at the very beginning of the Risorgimento in the late 1840s. But Piero Antoni's point was that Jews before emancipation had still belonged to Italy. They were still considered Italian nationals, right? Which suggested that equality was not a requirement for nationality, and that Jews should be considered nationals in Tunisia, whether or not they were equal with Muslims. What we see here is not just disagreement between Piero Antoni and the North Africans with whom he was working, but also one of the ways in which Jews, and particularly Tunisian Jews, present a tricky problem for these questions of legal belonging, right? And this is partly because when most people who have studied the history of citizenship tend to gravitate towards this idea of a binary, right? That you're either a citizen or a foreigner. But Jews in Tunisia don't fit into this binary because they were not full citizens in the sense that they didn't have full rights. They were dhimmis, but they clearly belonged, according to Piero Antoni and al-Malik and Hussein. And this is part of why I insist on the idea of legal belonging and this idea of the spectrum of rights as being a much more useful way to understand how rights actually worked out in the 19th century. Okay, we're running out of time. And I do want to make sure that we leave some time for questions. So I'll just say very briefly, first of all, that you'll have to read the book to find out how it all works out in the end, which hopefully you'll be able to do in about a year. But I do want to give you a sense of the sort of denouement of the case. In the end, the court did rule, the final court that adjudicated the case did rule that Nissim Shamama had died a Tunisian national and applied Jewish law to the case, although the great twist is that the way that the court interpreted Jewish law was very surprising. And if you'd like, you can ask me about that. But the tragedy of the case was that by this time, all of the potential heirs, Aziza, Nissim Jr., Qaid Momo, had long run out of money to pay their lawyers, the legal fees, and their living expenses. And so everybody, including the Tunisian government, had sold their shares of the estate to this guy, a banker named Émile Deranger, who was of German Jewish origin, but who had converted to Christianity and who lived in Paris and who basically sort of went around buying up all the shares to the estate, such that by the end, the only winners were him, the bank, this banker, and then of course all of the lawyers who got paid astronomical sums to argue the case for 10 years in the Italian legal system. So in conclusion, I just want to repeat that what I think is so interesting and ultimately important about the Shamama case is to help shift our perspective away from this idea of citizenship as a binary and as really sort of something that gets invented in Europe, and towards a more expansive approach invited by the idea of legal belonging, right? And it's a way to move the story away from sort of a purely Eurocentric story to one that plays out across the Mediterranean, and one in which Jews are actually central. I think this is something that can help us reimagine not only the history of citizenship, but ultimately also the present and future of citizenship, and is precisely what I think is so interesting about Jewish studies and North African Jewish studies and Mediterranean Jewish studies is that it can use these somewhat unexpected, often long forgotten stories to make us think in new ways about the past, and thus to help us reimagine the future. And with that, I'll end. Thank you.
Well, thank you so much, Jessica. It was a fascinating talk, and it really raises a lot of really interesting questions. So I'd like to read you a few comments and questions, and also invite others to please submit your questions in Q&A, and Jessica will try to get to as many as we have time for. The first question came from Linda Holbert. Was how did Italy benefit if Shamama were determined to be Italian? You may have partially answered this, but
no, that's a great question. There are different ways of answering it. I mean, in some ways, Italy didn't really benefit at all because, the Italian state, they were going to take taxes on the inheritance, sort of whatever happened. And they were tasked with adjudicating the case because this guy happened to die being domiciled in Italy. But I would say, so it's one way of answering it is that Italy really wouldn't have benefited. But I would say that people like Mancini were very invested in the narrative that Nissim Shamama had died an Italian, because for Mancini, it wasn't just about, winning the case. He obviously liked to win, as most lawyers do, as most people do, but it was also about sort of a chance to explore and prove his ideas about nationality and nationality law, right? One of the things that makes Mancini so interesting is that he sort of married nationalism with international law, and particularly international private law. And in arguing that Nissim Shamama was an Italian, he was really doubling down on a couple of things. First of all, on the importance of heritage and blood in determining who was Italian. Now, I didn't really get into this, but in Nissim Shamama's, or in the argument that Nissim Shamama had died Italian, it wasn't just that he had applied for Italian citizenship in 1866, but also that he made a claim to having Livornese origins, to having ancestors who were from Livorno. Now, there was a whole community, a very prominent community of Livornese Jews, so-called Livornese Jews living in Tunisia, actually in other parts of North Africa as well, but especially in Tunisia. And the sort of assumption was, or the presumption was, that Nissim Shamama had some connection to this community. Now, this in itself was disputed, like almost every aspect of the case. But Mancini really doubled down on the idea that because Nissim Shamama descended from Italians, he had to be Italian. And it was this very almost almost racially driven idea of what it meant to be Italian, that if you were descended from Italians, then you didn't need to apply for nationality. You didn't have to go through the same kind of rigmarole that a quote foreigner, that a true foreigner, somebody who had no Italian blood, would have to go through. So I would say, even though Italy didn't necessarily stand to benefit, certainly the Mancini had a sort of horse in the race, as it were, when it came to proving that Nissim Shamama died Italian, because of all of his ideas about what nationality was and what it meant to be Italian.
Excellent. Well, we have a comment and question from Noam Siena. Fascinating and engaging as always, and can't wait to read the book. I'll second that for sure. So Noam writes, I understand that for the sake of time, use the simplified term of Jewish law as a kind of homogeneous category, parallel to Italian or Tunisian law, Jewish law. However, it comprises many schools of thought and possible interpretations, as you alluded to at the end. And I'm curious how this came into play in this case. Could you speak more to how the Shamama affair was debated within rabbinic Jewish circles? I seem to recall Ben Amazah getting involved, and various ways Jewish law was thought to apply. And if I may just piggyback a little question, maybe elaborate a little bit more about how you use the term Jewish nationality was being, in some ways, being thought about or used. So how that might fit into this question as well, which really intrigued me. So.
Sure. Yeah, no, these are great questions. So, right. So I absolutely, you're right, Noam. I didn't have time to kind of get into there's a whole other sort of chapter dimension of the case, which is precisely the intra-rabbinic disagreements about how Jewish law should sort of be interpreted in this particular case. And interestingly, that also happens very shortly after Nissim Shamama dies. Just a couple months after he dies, the first rabbinic responsum, known in Hebrew as a teshuvah, is written by a very prominent figure, at least politically, the Rishon LeZion, the chief Sephardic rabbi of Jerusalem, which of course at the time was under Ottoman rule, a man named Abraham Ashkenazi. And he wrote a long responsum in which he argued that Nissim Shamama's will, although it seemed to lack the things that a kosher will should have, nonetheless was valid according to Jewish law, right? Which was probably something that he did at the request of Aziza Shamama, who wanted to sort of hedge her bets such that just in case Nissim Shamama was determined to have died a Tunisian and Jewish law was applied, the will might still be upheld. And Ashkenazi's teshuvah ignited this big debate that raged really throughout the 10 years of the lawsuit, and somewhat in parallel, because it largely happened in Hebrew and among rabbis who were writing. Abraham Ashkenazi writes his teshuvah in Hebrew, which of course the Italian judges can't read, and indeed don't read, right? Nobody except the other rabbis ever refer to Abraham Ashkenazi's teshuvah, but it becomes almost like one of these sort of test cases for rabbis across the Mediterranean who weigh in on whether they think Nissim Shamama's will was valid according to Jewish law. And it's interesting. One of the things that I've written a little bit about is that I don't think that the debate, the rabbinic debate, the intra-rabbinic debate about Nissim's will plays out neatly along sort of Sephardi versus Ashkenazi lines or European versus Mizrahi or anything like that. It's actually one of these things where, people from all different Jewish contexts and Jewish legal traditions have very distinctive views. Partially because it seems like wills are one of those areas that leave a fair amount of leeway, legal sort of wiggle room in terms of understanding what Jewish law says. And so the ultimate sort of ruling of the Italian judges is that Jewish law that Jewish law actually validates Nisim Shamama's will, but they don't rely on any of these rabbinic responses written in Hebrew because they can't read Hebrew. They rely mainly on a couple experts, one of whom is a rabbi, a guy named Elia ben Amozek. You mentioned him. He's a very important sort of philosopher and Kabbalist and thinker who lived in Livorno at the time. And he writes a couple very long books in Italian about why Nisim Shamama's will is valid according to Jewish law. But actually, they also rely on this professor of Jewish studies who is a avowed atheist, and who has his body cremated when he dies because he's so anti-tradition. But he's hired by the other side, ironically, to prove that the Jewish law does not consider Nisim Shamama's will to be valid. He also writes in Italian. And so these are the sort of interlocutors that end up convincing the Italian court of what they should say when it comes to determining the validity of the will. And then Daniel, you asked a little bit about Jewish nationality and what does it mean for sort of, for Nisim's Jewishness to be his national law. And that is something that is, one of the more kind of unexpected and a little bit sort of, odd aspects of the case, because of course, Jewish nationality wasn't a thing that then really had legs, right? It wasn't something that a lot of people were talking about or arguing about, except in the context of Zionism and other forms of Jewish nationalism, right? But of course, that was a political movement and a state-based movement, and not about this idea of this sort of transnational legal status. And part of what I argue is that the very fact that the courts and the lawyers took seriously the possibility that Nisim Shamama's national law was Jewish law suggests just how unstable these categories of nationality as a legal status and nationality as an ethnocultural status were, right? There was an enormous amount of overlap. Some of that overlap was deliberate. Like somebody like Mancini, that was his whole purpose in life, was to try to get to people to recognize the importance of the overlap between legal status and ethnocultural status. But it also extended to Jews and people thinking about Jews, right? And in some ways, this was the flip side of that was the sort of ugly accusations of dual nationality, right? Of disloyalty, the idea that Jews were always going to be sort of more loyal to other Jews than they were to whatever state that they lived in, right? And so this was not unrelated to the currents of anti-Semitic thought that were running really throughout Europe at this time.
Great. Well, there's another question, and this does kind of resonate with contemporary times. Your last comments. The question from anonymous attendee. Great topic. How might this framework of legal binding, or perhaps legal belonging, as you mentioned, apply to the modern context of undocumented immigrants living in the States, paying taxes, etc. Mm-hmm. And maybe I'll take the prerogative of kind of chairing your talk to throw in also, one of the categories that was brought up was possible categories was statelessness also. Mm-hmm. And so I think statelessness has some very interesting resonances today. So maybe what is this, perhaps, what can the case of Nisim Shamama tell us about these sort of contemporary issues, I think, that are of interest, I think, certainly in the Jewish studies field.
Mm-hmm, mm-hmm. Yeah, this is a great question, and one that I've thought about a lot. And I think that, again, I adopt this term legal belonging largely because I'm dissatisfied with the idea that everybody has to exist on one side or the other of this imagined boundary of citizens and foreigners. And I think that undocumented immigrants living in the United States are a very obvious example of people who are very much part of the civic fabric, who pay taxes, who contribute in all kinds of ways, and yet who formally on paper are excluded from citizenship. To me, it seems a gross oversimplification to just say that they're out, right? To say that they're not part of America, and I think that they do belong, and that there are both informal and formal ways in which they are attached to the state, to the polity, to the broader community. And so I think in that sense, legal belonging is something that can help us understand the past, but can also help us understand the present. And there are other sort of lawyers specializing on questions of citizenship, sociologists, who have made similar arguments about the need to expand our understanding of citizenship beyond formal citizens and to include, precisely in the American context, undocumented immigrants. So I'm trying to kind of speak in dialogue with them to connect the past and the way we understand citizenship in the past to the present. And yeah, the question about statelessness, absolutely. In some ways, that what's so interesting about the Shamama case is that, you know, when the case was being tried, the category of statelessness was itself fairly new, and also something that was considered sort of taboo, right? Nobody really ever wanted to talk about statelessness. It wasn't something that people really had a good handle on. And the fact that the courts were willing to call him stateless is, you know, in some ways, sort of, you know, part of the history of the perception of Jews as these eternal cosmopolitans, the eternal wanderer, right? In fact, they use the term cosmopolitan, which I think is a code word for sort of rootless Jew, basically. And it's, you know, and it's also, again, gets to the instability of these categories, right? That in the late 19th century, when we think all of this stuff is worked out, it really is actually still radically uncertain what it means to have a state or not, what it means to be stateless.
Well, thank you so much, Jessica, for such a fascinating talk. Keep posted, everyone, for the publication of the book. We're really looking forward to it. We want to thank everyone for attending this lecture, and again to thank Jessica for agreeing to join us virtually for this talk today. So thank you, everyone.
Thank you all. It's been such a pleasure. Thanks.
Yeah.